Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a corporate lawyer. Today, in a very simple way, we will discuss section 35 subclause 7 of B.N.S.S. Basically, the said section provides protection against the illegal arrest or arrest to be made in the arbitrary manner. But for the application of section 35 subclause 7 of B.N.S.S, it is required that the concerned offence is punishable with imprisonment for a term less than 3 years, and apart from that, the person to be arrested is either infirm or above the age of 60 years. In that scenario, the arrest cannot be made without the prior permission of DYSP. Basically, the said section is providing protection to the specific class of individual, and that's why if a person to be arrested is either infirm, means physically weak, or above the age of 60 years, in that scenario, the special protection is provided to him or her. But the key point is that the offence must be punishable with imprisonment for a term less than 3 years, and prior permission of DYSP is sine qua non. Now the important question arises, already we are having section 35 subclause 3. Then why there is a need to provide special protection by the virtue of section 35 subclause 7 of B.N.S.S. I want to clarify that both the sections are based on same analogy and having resemblance with section 41A of CRPC. 41A of CRPC also provided protection against the illegal arrest, but it is pertaining to offences punishable with imprisonment up to 7 years. And the said restriction is not given in section 35 subclause 3 of B.N.S.S. And apart from that, as far as section 35 subclause 7 is concerned, the restriction is given in the form that the imprisonment must not exceed 3 years or more than 3 years. If it is below or less than 3 years, in that scenario, the section would be applicable, otherwise it would not be applicable. And apart from that, both the sections are applicable regarding the arrest of individuals to be arrested without a warrant, specifically in a cognizable offences. Basically, in section 35 subclause 3, there is a requirement of notice. It says that the police officer shall issue a notice to the individual to be arrested against whom a reasonable complaint or information or suspicion is in existence. In that scenario, if the arrest is not required, he could direct the accused to appear before him or before the IO. And apart from that, it must specify the time, date and other specifications, which is not the requirement of section 35 subclause 7. It simply says that no arrest shall be made without the prior permission of DYSP in cases where the offence is punishable with imprisonment for a term less than 3 years and the concerned person is either infirm, means physically weak, or above the age of 60 years. So basically, we could say that there is a difference between section 35 subclause 3 and 35 subclause 7. Because in 35 subclause 3, there is a requirement of notice. Notice in lieu of arrest, we could say that. The section is applicable, I am specifying section 35 subclause 3 when the arrest is not required. Offence is cognizable, and apart from that, the accused is going to cooperate. And if the concerned police official is of view that arrest is not required, in that scenario, the benefit could be given. But the said requirement is not of section 35 subclause 7. It straightforward says that no arrest is required to be made in offences which are punishable with imprisonment less than 3 years. And apart from that, second condition is that the person must be either infirm or above the age of 60 years, to be noted. Now the important question arises, how to apply section 35 subclause 7 in the practical way. To be noted that the said section is resembled with section 41A of CRPC. And apart from that, regarding 41A CRPC, we are having two important judgments of Honorable Supreme Court. Arnesh Kumar versus State of Bihar, Siddharth versus State of UP. In both judgments, it is specified that the arrest should not be made in the mechanical way. So if the arrest is going to be made in the mechanical way, there is non-compliance of the protocol. In that scenario, for the compliance You may submit the objections before the concerned magistrate as per guidelines of Honorable Supreme Court verdict cited as 2016 SCC page 277. Even you may move for quashing or for anticipatory bail because it is also concerned with arrest in cognizable and non-bailable offences, punishable with imprisonment for a term less than 3 years. So now it is clear to us what will be the benefit of section 35 subclause 7, how it differs from section 35 subclause 3, and how to have the practical benefit of section 35 subclause 7 of BNSS. See you in the next video. Till then, Jai Hind, Jai Bharat.